Welcome. This is Court of Appeals Division 1, CA TX130003, KLP Enterprises versus the Arizona Department of Revenue. This is time set for the oral argument in this case. For the parties' information, these proceedings are being recorded both audioly and visually, and so you will be able to see this, hopefully, if the machinery works correctly, the equipment works correctly, you'll be able to see this on YouTube in a week or two. As you approach the podium, please state your name and who you are representing. Each side will have 20 minutes to present their arguments. Appellates, you may reserve a portion of your time for rebuttal. If you'll tell us how much time you would like to reserve for rebuttal, we will try not to horn in on your time too much. I said the podium, the time on the podium is your indication of how much time you have left, including your rebuttal time. So if you tell us you want 5 minutes of rebuttal time, and the clock says you have 10 minutes, that includes your 5 minutes of rebuttal time. So with that in mind, if you will begin.
Good morning, judges. My name is Eric Gear. I'm with Jennings, Strauss & Salmon. We represent the appellant KLP Enterprises, Inc. With me today is an associate, Ryan Womack. I would like to reserve today 5 minutes of my time for rebuttal. Preparing for argument today, I tried to think of a catchy phrase to open up my argument with, but this case really does not lend itself to such technique. It really is a straightforward case involving issues of statutory construction and interpretation and the application of tax statutes. There's hardly anything that, for most people, is less intriguing than that, at least on a factual basis.
Farming is an exciting, opportunity. They are wonderful people who do wonderful work, and we've got to construe a statute with a regulation.
I agree, Your Honor. As far as legally, there are some very interesting issues here, and for those of us involved in the transaction privilege tax field, and I assume some of our audience here also falls into that category, I believe the issues presented here are unique, and I believe that they are intellectually stimulating. So I'm just going to dive right into the first issue that I'd like to address, which is what standard applies to the court's review of this statute. As you probably have seen in the briefs, there's a disagreement here as to whether this is a challenge to the scope of the prime contracting tax statute or whether this is a claim for an exemption or a deduction. The difference between those two is material. In a case where a taxpayer is challenging the scope of a statute that creates a tax, the review is that the statute shall be construed strictly in favor of the taxpayer, and any ambiguities should be construed in the taxpayer's favor. On the other hand, if the issue is one of exemption or deductions, then the statute is construed the other way, and any construction needs to be against the taxpayer and in favor of the state. And so here, while I think the arguments are clear in the briefs, the department has continued to argue that what KLP's position is a claim for an exemption or a deduction. That's just not the case. KLP's argument is that its activities do not fall within the scope of 455075, the prime contracting tax statute. The department correctly states in their answering brief, and KLP agrees, that there is not and never has been an exemption to the prime contracting statute that would carve out services performed to prepare improved farmland for crop production. That's an undisputed issue in this case. The question before you today is there even a need for an exemption or a deduction? Because if the activity performed by KLP is not prime contracting, which we'll address in a minute, then there would never be an exemption. It would be superfluous. And so our argument here today is identical to the one that was addressed by the court in the Wilderness World case, Supreme Court case involving whether or not river rafting is within the scope of the amusement tax. And if you look at that case, the court, looking at issues almost identical to the ones you're facing here, only dealing with river rafting instead of prime contracting and farming, and whether those two, whether improvements on improved farmland constitute prime contracting. That case was looking at whether river rafting is within the scope of the amusement tax. And in that case, the Supreme Court said that the statute has to be strictly construed against the state and that any ambiguities would be construed in favor of the taxpayer. I submit to the court that this is the identical type of argument, directly analogous only under the prime contracting statute. Therefore, the same lens needs to be applied today as you are reviewing the scope of the prime contracting tax. So that brings me now to a second rule of construction, one which will also be important to keep in mind as you go through the prime contracting tax statute and determine whether or not these activities by KLP are taxable prime contracting. And that is...
Let me make sure I understand. What you're saying is we should be looking at the statute de novo, but the tilt will depend upon whether it's a scope or an exemption.
The ruling by the trial court is reviewed de novo to the extent it's an interpretation of the statute. Yes, sir. To the extent that the issues before you involve facts that would have prevented summary judgment, which I do believe there are some of those, both based on the trial court's ruling, for example, that removal of the citrus orchard trees was not part of crop rotation. I believe that gets into the issues of facts, and you have to draw any inferences in fact in favor of the taxpayer, just like any other summary judgment ruling. But as far as you're looking at issues of statutory interpretation, the trial court's ruling is de novo. But when you're reviewing that statute, if you find an ambiguity, then you need to interpret it in our favor. And also, if you are looking at it and it could go either way, it has to be strictly construed to minimize the scope of the prime contracting tax. That second rule of statutory construction is one that involves the court's deference to administrative agencies and their interpretations of statutes that they enforce. And we will dispute what the department's interpretation was of the prime contracting tax. That's the issue we'll get into regarding the Rule 15-5-606. But KLP's position is that rule evidences that the department deemed services like KLP's, which were services performed on improved farmland in connection with agricultural production, the department viewed those types of services as outside the scope of the prime contracting statute. That's why they adopted R 15-5-606.
But they adopted that rule before the statute, which came into effect in 2002. So what's the implication there?
Your Honor, I'll address why the statute that was adopted in 2002 did not change the scope of the prime contracting tax. The statute only clarified what services by prime contractors is subject to tax. And they said what the legislature did is adopted a previous tax ruling from the department that says lawn maintenance services not taxable. Landscaping by a lawn maintenance company or others involved in landscaping is taxable. But that's stuck in subpart J under the prime contracting tax. It did not amend the definition of prime contracting. It did not amend the definition of contractor, and it did not create a new tax on a unique business activity. As you all know, in Arizona, we have distinct taxes for business activities, retail sales, prime contracting, it goes on and on, amusement. The legislature could create a brand new tax, redefine what that tax is, and they could have defined landscaping and what type of entities are considered to be landscapers, but instead it stuck it in the prime contracting tax. All it was doing was taking the department's clarification of what prime contracting is and what it includes and codifying that in subpart J. So to the extent that this case is, and I believe our argument is entirely that KLP services do not fall under prime contracting, any subpart to that statute will not apply unless you first find that this is in fact prime contracting, which KLP says it's not, and the department's rule that was in effect during the relevant time periods to this appeal also said is not prime contracting. So with that said, assuming the court agrees that the rule is consistent with KLP's interpretation of the statute and KLP's activities were not prime contracting, it remained in place from 1998 to 2011. Where a department's rule has remained in place for a long period of time, it should be given great weight and should not be disturbed unless manifestly erroneous. And so that's a second rule of construction that we will ask the court to apply here as you review the prime contracting statute. Now, with those rules of construction in mind, the next issue is, did KLP's work actually constitute prime contracting under the prime contracting statute? I know the court's read the briefs. I'm not going to go through each of the different activities that KLP performed in their invoices at this time. I'm just going to talk generally about what is prime contracting and why farmland, work on improved farmland, does not fit within the prime contracting statute. Under the statutes, it's kind of a three-tier definition of prime contracting. This is ARS 425075P. At least that's what it's cited to in the briefs. The statute has not changed, even though the numbering was slightly different at the relevant time period. Prime contractor means a contractor who supervises, performs, or coordinates the modification of any building, highway, road, railroad, excavation, manufactured building, or other structure, project, development, or improvement. That statute incorporates the word contractor, so you have to look at the definition of contractor in P2, which says contractor is synonymous with builder. And then it goes on to say who performs services that modify, and then the same list of types of property that the definition of prime contracting included. Thus, in order to constitute prime contracting, the services of the taxpayer had to be acting in a manner that is synonymous with building and had to be performing modifications to one of the types of property identified in the definition of prime contracting and contractor. KLP's position is that improved farmland is not one of the types of property that is listed within the definitions. And so it's undisputed that the statute does not specifically identify farmland. So the department relies on the catch-all general provisions at the end of the listing where it says building, highway, road, railroad, excavation, manufacturer, building, and then the department relies on the language or other structure, project, development, or improvement. Well, this interpretation that the department advances is contrary to the doctrine of e justis generis, and I'm sure I butchered that, but that's also out of the Wilderness World case. And what that doctrine stands for is that where the legislature has listed a set of specific types of things and then thrown in at the end a general category, the interpretation of the general phrases has to be consistent and take into consideration the list of the specific items that were listed. So in this case, the only way other structure, project, development, or improvement could be used to apply to improved farmland is if improved farmland was similar in nature or scope as the items listed before that phrase: building, highway, road, railroad, excavation, and manufactured building. I submit to the court that farmland does not, in anybody's mind, ring similar to any of those specifically listed types of property. Improved farmland is its unique own thing, especially in this state where farming is such a major part of our economy. If the legislature meant to include work on improved farmland, it would certainly have been expected to state that in this statute, which this definition has been around mostly unchanged for a very long period of time. The department, however, would have you interpret that language defining contractor and prime contractor to include improvements to any real property. In fact, the department says in its brief on page 15, it should not come as a surprise to anyone that altering real property for others falls under prime contracting classification. That's not what the legislature said. It didn't say real property. How easy would that have been if that's what the legislature meant? It would have said contractor is anyone who does these things to real property, modifies or improves real property. It would have encompassed everything. There would be no ambiguity. There would be no doubt. But it didn't do that. It went through the task of specifically identifying the types of property, and I'll submit to you that if you look at them, they're all residential, commercial, or infrastructure type tasks that it intended to tax because that's what builders do. Builders don't farm. They don't prepare farmland for the next production of crop. Builders build things. They build roads, they build highways, they build buildings. That's not what...
Houses, barns, but not...
Absolutely, Your Honor, and if this were...
disking or...
Right, if this were a case about building a farmhouse or a barn, we wouldn't be before you because we would have paid our tax. That's building. This is farming. It's a necessary service or step that a farmer has to go through in order to harvest, cultivate the soil, and then harvest and grow the crop. And so KLP submits that the department's view of the statute that would encompass any work done on any real property runs directly in contradiction with the words of the statute itself, as well as the doctrine of e justum generis.
So send you back to law school for Latin class.
I wish they still taught it, or at least that I took it. I don't even think it was offered, Your Honor. So that brings us to Rule 15.5.606. And before I start talking about the specifics of that rule, I want to explain why we believe this rule supports our case. There was no deduction. There was no exception to the prime contracting statute found in the statute that would authorize the department to create its own exception or its own deduction or exemption from the prime contracting classification. So the only logic that can be applied to this rule is that the rule was intended to be a assistance to the taxpayers in defining the difference between prime contracting and agricultural production on improved farmland. And to support my statement, that language is found directly in the concise explanatory statement, which is quoted extensively in the briefs, where the department says what this rule does is it defines the difference between taxable activity and non-taxable activity. It doesn't say exempt activity or deductible activity. It says taxable or non-taxable, because what the department is doing in adopting this rule is drawing a line between what is prime contracting and what is farming or improvements to improve farmland. And so this rule supports our position. It's not binding on the court. It has to be interpreted to comply with the statute. The department had no authority to create its own rules, and I would submit to the court that you could stop with just your analysis of the prime contracting statute and finding that improvements to farmland done by KLP is not a contractor and is not prime contracting. That would be the end of the case. But to the extent the court needs to go farther and see what the department thought about this issue, you can look to the rule R15.5.606 and see that the department intended to carve out from prime contracting activities performed on improved farmland in connection with agricultural production. Now, underneath that, the department also says, well, even if this rule still applies, the activities you have at issue here are not implicated because they are not specifically listed in the subpart under subpart E to that rule. The subpart to the rule sets forth a lot of activities that are involved in the preparation of soil, just like what KLP was doing here. It has listed specifically plowing, it has disking, it has cultivating, and it has planting the seed. Those are all steps in preparation of farmland. For example, in this case, the farmland, some of it was alfalfa. When you plant alfalfa, it grows for approximately 3 years in Arizona. After that growth life is over, most farmers engage in a crop rotation process, plow the alfalfa under, and plant the next crop, which is usually cotton. That helps keep the soil healthy, keeps the crops productive. That crop rotation process starts with, number one, some sort of field clearing. Sometimes it's by disking, sometimes it's by raking, but there's a field clearing process involved. After that, there's usually a heavy disking. Then there's plowing. Sometimes that process goes back and forth depending on how much work is needed to kill the crop that's being replaced. But then you do a light disking, get the land fairly level, and then you come in and you laser level the field, because a field in Arizona that's not laser leveled, since we rely on irrigation and mostly we rely on gravity irrigation, a field that is not level, and that's kind of a misnomer. I'm not talking about flat. I'm talking about a consistent slope in the field, will not produce quality crops. The water will pool. The water won't get to crops that need water. And so this is all necessary for the farmer to engage in order to get to the point where they're planting seed. And one step I should cover is, in Arizona, you've probably driven past fields before and seen the berms running down the field, and perhaps a berm isn't described well enough in the briefs, but it's basically a hill of dirt that runs parallel to the field, and make sure that when you're watering a section, it's just not spreading all over the field, because that just lends to evaporation and uneven watering. So you put the berms in. But all of this leads up to the planting of the seed. And our argument in this case is each of these activities is as equally related, directly related to the production of crops as those items that are listed in the rule. In fact, they occur in between a lot of the steps that each of the rule identifies. And so for the department to argue, well, these aren't identified in the statute, therefore it must not be within the scope of the statute, that would be illogical. The department did not attempt to list every possible field preparation activity. In fact, it used the word cultivation, which, depending on whether you're looking in a dictionary or you're talking to an actual farmer, that word has different meanings, but it certainly encompasses most of the work that KLP did here. And so KLP would argue that the rule does in fact support its contention in that its activities were not prime contracting. The department says, well, wait a second, subpart A under the rule says that certain activities such as well drilling and leveling and other activities normally performed by a contractor is taxable. Therefore, your activities are taxable. That's inconsistent with the structure of the rule. If you look at the rule, subpart A identifies 6 or 7 activities that it says are generally taxable. But then B through E says, however, if you're drilling wells for purposes of checking groundwater, not taxable. If you're doing, I forget all the activities, but B through E all say, however, A is not taxable. Obviously, I got a little excited on the interpretation of the rule and ran past my time. I'll just say for the court that I think I covered why landscaping is not farming and is not involved in what we have here. And then on the issue of estoppel, in the event that you find that the rule is correctly interpreted by KLP, but the rule was nullified by the enactment of the statute, then KLP should be entitled to estoppel here because it relied on a rule that the department left on the books. So we ask that you remand this case with instructions to trial court either to reverse this judgment, enter a judgment in favor of KLP, or at a minimum allow the case to go forward on the triable issues of fact that might exist. Thank you.
I'm Scott Teasdale with the Attorney General's Office representing the Arizona Department of Revenue. May it please the court. The activities performed by KLP in this case are clearly and undisputably contracting type activities that would be taxable under the prime contracting classification. Prime contracting and contracting centers around doing things to real property. And that's what we have here. We have leveling land, we have excavating ponds, we have clearing out irrigation ditches. What KLP is doing in effect is claiming an exemption, saying that though all these activities would normally be prime contracting, because they're done on a farm, they're not taxable. So in effect, they are claiming an exemption. To clarify, however,
well, what they're probably saying, at least for the time that the statute was in effect, we didn't charge our clients the tax that now we have to pay. Because generally that's a pass-through.
well, that may be the case, Your Honor, but that is not something you have to do in order to be liable, as a lot of people have unfortunately found out, particularly in the prime contracting classification. There are certainly a lot of shade tree contractors who do not realize that contracting is taxable, that I have had the unfortunate experience of running into.
So a contractor who works on the farm and helps get it prepared for planting is subject to the TPT like any other contractor.
I'm not sure I would say get it ready for planting, because there are activities getting ready for planting that are deemed by the department to not be within the scope of the prime contracting classification. I was just getting to that. Okay. The regulation 155606 was not intended to create a regulatory exemption that does not exist in the statute, because the department is not empowered to simply declare exempt things that are in fact taxable. What it was intending to do, however, was to differentiate agricultural production, which it views as not prime contracting, from activities that it views as prime contracting. And for that purpose, it enacted that regulation. We see in Section A, leveling, ditching, well drilling, and original land clearing is taxable under the prime contracting classification. We then have B, C, and D, which I believe relate to the pollution abatement exemption in the prime contracting classification, which is not at issue. Currently, that's at 425075B6. We then get to E, agricultural production on improved farmlands is not taxable, and then Section 1 goes on, gives specifics: cultivating, disking, planting, plowing, and seeding. In that, we look at A and we see that it says original land clearing is taxable. Naturally, when an old field of alfalfa, for example, is plowed under, that is, in a way, land clearing, but the department views things like disking and plowing, which would be that process on improved farmland, to not be within the prime contracting classification. However, the taxpayer in this case is taking activities, leveling land, building ponds, and doing other activities which are clearly prime contracting, and saying, because they facilitate the farming activity and because they're on a farm, it's exempt. Effectively, that's their case. They are claiming that if you do it for a farmer on a farm, even if it would have otherwise been contracting, it's not taxable. And we don't find that in the statute. Now,
that would require legislative action.
Yes. And I won't bother reading through the definitions of prime contracting and contracting, but certainly, excavating and leveling land, these are contracting activities, regardless of whether they're done on a farm, regardless if the leveling is done to facilitate irrigation flows. We think it's simply, without question, a taxable activity. And when you look at what their activities are, it's building berms, removing trees. You also get to the statute. You get to the statute, and the statute, before it was even modified to discuss landscaping, had already been interpreted to tax grading or leveling land, because that's clearly within the definitions of contracting and prime contracting. Once Section J was added in 2002, it states that the gross proceeds or gross income derived from landscaping activities are subject to tax under this section. That's the prime contracting section. That means those activities are prime contracting. And it says that those activities include grading or leveling ground. It includes felling trees or removing or mulching tree stumps. Those are other activities. They removed old citrus orchards. Again, taxable activities.
Was J really a codification of the department's prior?
Yes, Your Honor. The department had issued, I believe it was a TPR 011, if memory serves me correctly, that basically said exactly these same things. And when the legislature saw that, they evidently agreed and adopted it pretty much verbatim, that these activities would be taxable. Now, landscaping, when I hire a quote landscaper, that's for my yard work, okay, and that's their contention. Well, this was just intended for residential landscaping. Well, the legislature didn't say that. These landscaping activities, which they say are prime contracting, agreeing with the department's existing interpretation, they did not say that these activities are exempt if they're done on a farm, or only if they're residential, or only at an office, or anything like that. They rather said that these activities, which include building and modifying irrigation berms and other activity they did here, were in fact prime contracting.
Do farmers or people who work for farmers get a break outside of the prime contracting?
Well, if a farmer does it himself, then he's not acting pursuant to a contract. So though he's doing contracting, he's not a prime contractor. To be a prime contractor, you have to be acting in pursuant to a contract. You have to be hired to do this work, do an improvement, a building, an excavation, or one of these other things that's defined as contracting. So if you see a farmer with his own tractor out there leveling his own field, that's he's not acting as a contractor because he's not acting pursuant to a contract. He's doing his own work. It's like if you paint your house, you're not acting as a contractor. If you hire a painter, that would be subject to prime contracting.
Farmers are fairly entrepreneurial, so if H&R Farms also is H&R Machinery, and would the farmer then get the exemption because he's essentially got all of his own equipment and doing on his own work?
If he hired a separate entity?
No, he's the entity.
No, well, if he's the entity, if you're a farmer and you're doing all your own work, you're not doing that contracting work pursuant to a contract with another person. So no, you would not be taxable for doing your own work, and there's no farming classification in the transaction privilege tax. Another reason we think that the regulation is misinterpreted is E2. Clearly, this was not intended to be an everything that happens on a farm is exempt regulation. Agricultural production does not include the following activities: installation or repair of drainage or irrigation delivery systems. Now, the berms are done for irrigation. The clearing out of irrigation ditches that had filled up with sand, that's repairing the irrigation system. Construction or repair of farm buildings, I don't even think they're arguing that if you build a barn on a farm that wouldn't be prime contracting. They're saying if you're leveling the surface of the land or digging a pond, it would not be. But and then C, the catch-all, any other activity which is not directly related to the production of crops on improved farmland. And that's really, I think, the crux of the dispute are these catch-all provisions, the directly related or not directly related. And the question is,
then, at least in the department's notion of directly related to production, planting and harvesting?
Cultivating, disking, planting, plowing, seeding. If you're harvesting the crop, that's not altering the real property. Generally, you're generally taking the crop off. So I don't think that would be within the prime contracting classification in the first place. And some of these activities, as I said, they will clear the ground of an alfalfa crop and put in another crop, and that would not be included. And in fact, the department found activities that they performed, such as disking, were not taxable. There was one invoice where they had disking and I believe leveling, and it was not broken out, and we were not given the ability to segment out what was taxable and what was not taxable, and the default is taxable if there's no way to break it out. But wherever it could be found to be simply disking or plowing, then it was separated out by the department and not treated as taxable.
So the releveling would be, at least department's idea, it wouldn't be exempt under 2A.
No, we wouldn't view cultivating as being that broad. This is preparing the land so the cultivation can take place. We don't accept the theory that the taxable leveling when leveling is clearly taxable, can only occur once at the very beginning of the farm. You level it, and then 2 years later you level it again. First time's taxable, next time's not taxable, and on and on. Some of the leveling here, one of the farmers had a gas line installed, and the gas line contractor had leveled the land after they put the gas line in. That's on a farm, on improved farmland. Then it settled more, and they came in and did another leveling job to fill that in. Leveling is taxable. There's not a clear line where you can say, well, okay, when the gas line contractor did the leveling on improved farmland, that's taxable, but then when you fix that because it settled some, doing more leveling, then that one's not taxable because you're working for the farmer. There's nothing in the prime contracting classification that says if you're doing work for a farmer, then your proceeds are exempt if you're leveling land for a farmer. And these activities fall within the prime contracting classification. The vast majority of what farmers do doesn't. But when you're altering real property, when you're building ponds, you want to talk about an excavation 1,320 feet long, 24 feet wide, 15 feet deep, that's an excavation for you. That's a quarter-mile long. These are not peripheral things, harvesting crops. These are major improvements to real property that are going on by these people. Now, I do want to comment on something that was in their reply brief. This regulation's since expired, and they suggest in the reply brief we're now going to be taxing all these farming activities. The department's interpretation has not changed simply because this regulation's expired. There's a moratorium on rulemaking. These come up, and the department either has to renew them or let them expire. They let them expire. They cannot issue a new regulation under the governor's prohibition on rulemaking at this time. They were going to issue a transaction privilege tax ruling on this subject. The legislature for the last few sessions has been very interested in TPT simplification, and the governor last session was pushing to even eliminate the prime contracting classification. So events are moving faster than the department's ability to issue a TPR, and right now we can't issue a new regulation on this subject even if we wanted to. So, but I didn't want to leave the impression that simply because this has expired that now the department is out there and is going to be taxing plowing and disking and seeding and harvesting as prime contracting, because its interpretation all along has focused not on the farming activity but on the alteration of real property by someone who contracts to alter real property. The concise explanatory statement is not very concise and is not very consistent with either the language of the regulation in our view, and certainly not the language of the statute. Certainly the statute is the primary source of authority. The regulation has to be consistent with the statute, and while the regulation is fairly concise, the concise explanatory statement we think is poorly worded in parts. It does give the impression that only the original land clearing is taxable, and we don't think that's consistent with the language of the regulation, where leveling continues to be taxable. The land clearing that is not taxable is the land clearing that is agricultural production, such as the example given when an alfalfa crop gets plowed under. That is not viewed by the department to be taxable contracting.
But after that, the leveling would still be taxable after the alfalfa is...
Yes, we don't view that as being directly related. We view that as preparing the land so that the agricultural production activity can take place. It is simply The directly related part of it is where where we come down and we look at the listing of the enumerated activities and say it has to be really tightly tied in there. It can't be the contracting activities because we're not empowered to create an exemption where leveling real property is henceforth not prime contracting.
Well, you don't want to at least say it for farmers and then get stuck when building some new highway someplace and you can't collect from contractors who are leveling a mountain.
Well, if leveling real property is taxable prime contracting, our view is it's taxable prime contracting whether it's on a farm or not. If building a barn or other structure is taxable prime contracting, which it is, if it's on a farm, it's going to be taxable prime contracting in the department's view. And I've got a few minutes left, but I think I've said all I have to say unless you have any questions.
Okay, thank you very much.
Thank you.
Counsel. We will take this matter under advisement and issue a ruling in due course. Thank you very much.